Good morning, folks. Thank you, Thurlock, for that introduction. As Thurlock says, my name's RODERIC GORMAN. I have a political hat as chairperson of the Green Party, but I'm laying that aside this morning, and I'm speaking, I suppose, in my role as a lecturer in DCU, where I teach constitutional law and EU law, issues that I suppose intersect in the context of what we're talking about today. In your packs there, I've done up a little document just basically focusing on the 28 EU member states and looking at whether they have a reference to the environment within their constitution. And I'm going to just talk of this idea of constitutional environmentalism, and I'm using that broad term initially. And this is any reference to the environment, animals, or ecological issues contained within a national constitution or similar Bill of Rights. So I'm going to break that down a little bit more subsequently, the different types of constitutional environmentalism. But I've just set out the 28 member states there and what type of specific rights they protect. But rather than just going through each member state, which I think could get quite dry quite quickly, what I'm going to try to do today is look at the reasons why certain member states, many of them within the EU, but some outside of the EU, actually decided to amend their national constitutions to insert a reference to the environment. And we have various reasons. Some of it is people power, ground up movement. In one situation, it's an egomaniac politician looking to stamp his authority, have a legacy on his national constitution. So I just think it's interesting, particularly, and I think it was useful that Ivana set the context in Ireland with the Constitutional Convention, and a result that I'd say certainly I was very disappointed in, and I'm sure many people here were disappointed, the failure to recommend, or the failure to give a full discussion to adding some element of constitutional environmentalism into Bunreacht na hÉireann. So after looking at the various ways in which the various reasons why the environment has entered constitutions in a number of countries, I'm just going to look specifically at the case of Ireland. And I'm going to look at one case where I feel that had there been a right to environment within our constitution, a different outcome might have emerged. Just as a case study, it's speculation in many ways, but I think it's useful because there aren't many cases in Ireland where environmental issues where environmental constitutional issues come to the fore. And finally then, I'm just going to, I suppose, raise a few questions about how in the future we can campaign, those of us as environmental campaigners can campaign to actually bring about some sort of constitutional change. So this broad term constitutional environmentalism, just a little bit, a few definitions, and then hopefully we'll get things a little more free flowing. But I basically break this down into three categories when you look at how the environment crops up in constitutions across the world. There are environmental rights as a broad heading, environmental duties as a broad heading, and then reference to animals, which is, I suppose, a subcategory but related. So when it comes to environmental rights, that again can be broken down into three separate areas: environmental procedural rights, the right of environment, and the right to environment. So environmental procedural rights, these are probably, I'm not going to say the least controversial, but they're the ones that crop up the most within national constitutions. And these are associated with participation in decision making, access to information, ability to access justice. Now, most people here would be aware of the very pertinent and very important statement of environmental procedural rights in the Aarhus Convention, something that has been ratified within Irish domestic law and within European law, and is a really crucial defence of that whole idea of environmental procedural rights. But we do see similar procedural rights mentioned in national constitutions. Then you have the right of the environment, and this is probably the most radical statement. And this basically sees that the environment is of value beyond its use, its benefits to ourselves as humans. And the environment should be seen as a good in its own merits and protected as such. And it is predicated on the argument that it's arbitrary to restrict justice and rights exclusively to interhuman relationships and to tolerate a situation in which interested parties are deprived of essential values in the distributive process on the basis of morally irrelevant factors such as their not being human. So that's the key issue, the key, I suppose, ideology behind the right of environment. And the Ecuadorian Constitution was amended in 2008 to reflect that sort of notion, and we'll talk a little bit more about that later on. Finally, then you have the right to the environment, and the right to environment conceptualizes the environment as a benefit towards humans. So each human has a right, has a stake within the environment. The environment doesn't have a value in its own existence. It has a value in light of its importance for human existence. And obviously, perhaps this right is a little bit more. It's a little easier to sell, maybe, to the majority of people than a sole moral right to environment on its own. But also, the right to environment is criticised by many people as being very anthropocentric. That this whole idea of basing the environment solely on its good for humans is problematic in itself. Environmental duties then, these are strongly stated in many of the European constitutions, and the bearers of these duties are either the state or the individual. So when it comes to the duty on the state, these are often very widely framed, and sometimes they're based on the type of principles that would be well established within environmental law and environmental policy, such as sustainable development. So there's an obligation within the Polish constitution as regards sustainable development, or we could have done with this in our constitution, proper planning is referenced within the Portuguese constitution. Some interesting ones there, if you just look at the Slovakian constitution there, the economy of the Slovak Republic is based on the principles of a socially and ecologically oriented market economy. So a directive there as regards how the economy should be regulated and run on an ecological basis. So quite an interesting approach adopted there. Some of these state environmental duties also correspond and are related to the use of natural resources. Then there's the duty on the citizen, and these again can be quite widely framed or quite narrowly framed. In the Estonian constitution, there's a duty on all citizens to respect the environment, while within the Czech Charter of Fundamental Rights, there's individual duties on citizens, and if you want to look at the document I provided, that gives a little more detail on the wordings and the difference of wordings in those situations. Finally then, I just thought I'd address the constitutional protection of animals. It's an issue, animal welfare, and that's something close to my own heart, and I'm sure of many people here. I think it's just interesting. Doesn't come up much. There's only, I think, 3 constitutions: Germany, Slovenia, and Sweden, where there is explicit reference to the protection of animals, or just an acknowledgement of issues of animal welfare within the national constitutions. Animals are also mentioned in the Maltese constitution, but solely as an element of property. Not particularly beneficial, I think, to animals in that particular case. So, looking then at some of the themes, why countries have amended their constitutions in order to make provision for environmental constitutionalism. One of the key themes is this idea of the emergence of new democracies, because across Europe in the 1980s, you see the southern European states, Greece, Portugal, Spain, emerging from the military dictatorships. Across the 1990s, you see the former Soviet republics emerging as democratic entities. And you see a spate of constitutional writing going on across this period of time. And those constitutions, many of them are influenced, I suppose, firstly as an element to break from the past, to get away from the dictatorship or the communist elements or influences that these countries were leaving. But secondly, the desire to be modern, the desire to have in their constitutions what is regarded as best practice at that time. And often best practice wasn't found in constitutions of other countries. Best practice was also often identified in international agreements, international human rights documents that were in place at that time. So, for example, then you look at the Romanian constitution. And Romania, they initially amended their constitution in 1991, straight after the Ceausescu regime, but they subsequently undertook a new revision in 2003, and Article 35 of that contained a specific reference to the state acknowledging a right to a healthy, well-preserved and balanced environment. And it was felt that, if you just look at the date there, 2003, Romania was meant to accede to the EU in 2004. It didn't happen until 2007. But many people are, certainly Ian Tax, and I'm probably massacring that pronunciation, but a Romanian legal academic, and he argued that part of the reason that this provision was inserted was to bring Romania in line with the EU requirements as regard the environment, because Romania had, and I think continues to have, a bad reputation as the quality of the environment. Now, so they felt it was necessary to put constitutional protection of the environment into their constitution as part of their joining the European Union, which is ironic because at that stage, and even at this stage, there isn't such a clear statement of environmental protection within the EU treaties, but nevertheless this desire for modernity, for being homogenous with other EU member states, was part of the reason why Romania went in this particular way. The Polish example is also interesting. The new Polish Constitution of 1997 put a number of environmental articles in there, a duty on the state to protect the environment based on the principles of sustainable development, and also a duty of the state to pursue long-term environmentally sound policies. They didn't go with the specific right to environment model, and indeed some would draw unfavourable comparisons between the model the Poles did go with and Article 47 of the former Polish Constitution, the Constitution adopted in communist times, because it said citizens of the Republic of Poland shall have the right to benefit from the natural environment, and it shall be their duty to protect it. So a type of right to environment in the old Polish Constitution, not reflected in the newer Polish Constitution. And again, I think that demonstrates the idea of a break from the past to try and get away from what was there. The language was reading some of the obviously this happening in Poland, there's not a whole amount of academic commentary in English on why the Poles went with the particular wording, but some of the material I found seems to suggest that the original proposal for the 1997 Constitution on the environment was actually was stronger, more robust, but because of the high unemployment in Poland at that time as it emerged, kind of developing its market economy, it would appear that original wording was watered down, and the reason it was watered down was concern that a high standard of environmental protection in the Constitution would impede employment, and that has been noted by a number of academic commentators. Hungary then, just finally on the Eastern European countries, Hungary never fully renounced or never fully changed its communist constitution. It only it made substantial amendments to it, but it never completely changed it until quite recently, 2011, and that's a very controversial process in itself, as the Hungarian government is regarded as considerably right-wing, and its activities as regards various changes it's made to the constitution have been heavily criticised. As regards the environment, I think it's interesting. Article 21 of the new constitution, Hungary shall recognise and enforce the right of every person to a healthy environment. So a strong right to environment there. But even Article 20.2, which says, ensuring that agriculture remains free from any genetically modified organism by providing access to healthy food and drinking water, by managing industrial safety and healthcare, and by ensuring environmental protection. So a specific reference to not having GMOs in food. So interesting. I'm not saying I'm supportive of the wider context in which this constitution is being amended, but it's just interesting to see a strong environmental protection being put forward on that specific issue, and a direct link being made between the environment and health. And I think that's very important from I suppose, selling the right to environment point, the fact that we should link the right to environment with that right to health. The second theme then, long-term public pressure, and I think this is demonstrated in the case of Germany, because after reunification in 1993, a special constitutional convention or commission was established to look at an overall redrafting of the German constitution. And in 1994, it recommended, as part of a number of revisions, an insertion of Article 20A into the German constitution that has a number of points on environment. Not a full right to the environment, but nevertheless has a number of references to the environment. And it was criticised at the time, again, for not going far enough. But this was seen in many ways as the culmination of the very strong German environmental movement that has been active in the 70s, and the move towards putting environmental reference in the German constitution had begun long before reunification in the 70s and the 80s. The various environmental groups within Germany were pushing this, and this push was continued as regards the specific issue of animal welfare, because green groups and the presence of the German Green Party in government at that time is regarded as part of the influence for the 2002 amendment that inserted the term "and the animals." So it was the environment and the animals will be protected, but through through the German constitution. So again, it's a combination and probably the mixing of the political scene at the time, both in 2002 and in 1993, but also that long-term public pressure. We go to France and we see the benefits of strong political leadership on a particular issue. And it is generally regarded that the Charter of the Environment, which was appended to the French Constitution in 2005, but also and importantly referenced within the preamble to the French Constitution. And by being referenced in the preamble to the French Constitution, this Charter of the Environment is able to be discussed and used by the Conseil Constitutionnel, which is the constitutional court or constitutional adjudicative body of the French of the French system. And the Conseil Constitutionnel, so that was pushed basically by President Chirac. In his 2002 re-election, he said he was going to make the environment a key element of his re-election campaign. He pushed it through the campaign. He pushed it once he did get re-elected. Obviously, he had that was the issue with Jean-Marie Le Pen, and he got re-elected quite easily. And was seen very much as an element of legacy building. But at the same time, he intervened with his own party on a number of occasions when his own party looked like they were going to modify or lessen the standard of protection that was incorporated. So as Borg and Whiteside say, it's no exaggeration to say that there would be no charter for the environment in the French Constitution had it not been for Chirac's personal, reiterated efforts on his behalf. And this sort of political leadership is again seen in the Ecuadorian Constitution, where President Correa was elected in 2006, I think, and as part of his election campaign, he pledged for the introduction of a new constitution, and part of this was this very strong protection of the environment. Article 71.1, nature or Pachamama, where life is reproduced and exists, has the right to exist, persist, maintain and regenerate its vital cycles, structure, functions and its processes in evolution. That's an artist's depiction of Pachamama there. When I googled it, it is represented in various ways through native Indian art. Bolivia in 2011 adopted a law on the environment, not on full constitutional status, but nevertheless interesting to see them going in a particular way. I won't go into it because I don't have time in huge detail. The Wheeler case shows that Article 71 being applied within the Ecuadorian courts. It's also interesting to note that environmental NGO, the Community Environmental and Legal Defence Fund, they invested an amount of money in supporting this drive to get Pachamama referenced in the Ecuadorian Constitution. I'm trying to find out a bit more about how much money did they spend, how did they influence it, but specifically a US NGO wanted this and came in, spoke to the Ecuadorian Parliament about the importance of inserting this. Maybe we'll get them into the next constitutional convention and they can put a little bit of emphasis on it here. Environmental protection is an uncontroversial amendment. It's in the Dutch constitution. It was amended quite early, 1983. It was the reference to the environment was put in at the same time as a range of social, economic and labour law rights. They all seem to have been much more controversial than the environmental right, and really there doesn't seem to have been any major discussion of the insertion of the right to environment in the Dutch constitution. Similarly, in the as you know, Iceland has been undergoing a process of constitutional amendment over the last few years as a result of its the fairly major economic collapse. A draft constitution was put to the people in early 2013. It includes a right to the nature and the environment. That provision wasn't controversial at all. However, the provision on Iceland's natural resources was quite controversial. It was this idea of creating a new form of ownership of Iceland's natural resources, and these were put to a separate vote when the full constitution, so the constitution was put to a vote and 5 controversial issues were put to separate votes. The new status for protection of natural resources got the highest yes vote. It got the most resounding yes vote at 82%. So as I say, Bullnock na hÉireann is one of only 6 EU member states that doesn't see a reference to the environment. And I see this as being an issue because I discussed some of the cases of the European Court of Human Rights there, where they found, even though there is no right to environment within the European Convention on Human Rights, 2 articles, Article 8, respect for private and family life, and Article 2, the right to life, they've both been used as means of dealing with people who have suffered loss, suffered damage because of environmental degradation. So non-specific environmental rights that are not specifically environmental rights are used to resolve environmental problems. And I just look at, sorry now I waffled on a little bit too much on some of the earlier stuff, but I think it's important to look at one case, Hanrahan versus Merck Sharp and Dome from 1988. Some of you may remember this, a farm I think in South Tipperary, farmer suffering from his livestock suffering from cattle deformities, ill thrift, grass not growing properly, and health problems within his family as well. Sued a pharmaceutical company that was a mile or 2 away, Merck Sharp and Dome, and sued in the area of tort law for nuisance created by the farm. Now, it was important that when the family took the case, they argued that they were suffering a serious issue, and they said tort law as it existed in Ireland didn't properly deal with this particular issue. It didn't vindicate the constitutional rights that they possessed, right to the right to life, the right to the person, and the right to property rights, all of which are protected under Article 40.3. Now, the court said that the tort of nuisance could be understood as an element of the state's duty to its citizens under the constitutional provisions on personal and property rights. And they said the application of the rights in question was primarily a matter for the state, and the courts are entitled to intervene only where there's been a failure to implement or where the implementation relied on is plainly inadequate to effectuate the constitutional guarantees. In this case, it could not be shown that the tort of nuisance was insufficient to protect the applicant's constitutional rights. So their only remedy was through the right of the tort law rather than constitutional law. And I would argue, when you look at what the plaintiffs were suffering in this case, they were suffering a lot more than what some of the successful plaintiffs in the cases before the European Court of Human Rights were suffering. So I think this case demonstrates why there is a gap in Irish constitutional law resulting from the failure to protect some element of the right to environment. So I suppose, I know I'm at my time now, so I suppose how, and this is maybe moving away from the strictly legal field to more the political and the influence field, how do we, looking at the examples from other countries, how do we change the constitution? We need to get public opinion on side. And while I know the environmental NGOs did a fantastic job in lobbying their members and getting them into the meetings around the country on the convention, I'm not sure if we got that message into the public sphere enough, and I think next time more needs to be done on that. I think we have to particularly make it clear that it's not a threat to employment, because that's the biggest stick that is used to beat, certainly in most developed countries, it's the biggest stick used to beat it. And I also think we need to emphasise that link between the environment and people's health, because I think people, when they say right to the environment, it's tree hugging, it's that sort of thing, and we need to show it's not that, it's something that impacts on all of us. You know, we mightn't get a Pachamama type amendment into our own constitution, but I think any reference to the environment is something that can be interpreted by future courts, and the provisions in France and Germany have had more than maybe their initial influence. They've permeated other elements of government and society. And finally then, it's a question of getting political players and the social partners involved. We've seen in France what happens when someone on well on the right of politics is convinced of the importance, even if it's on an egotistical type of view. When someone is convinced of the importance, it can be used to make a difference. Thanks very much.